Good afternoon. Attorney Protective would like to welcome you to today's webinar, Pay Now or Pay Later, the Ethics of Billing and Avoiding Fee Disputes. Please reference your materials for information about today's speakers, Eric Krepp and Aaron McCartney. With that, I would like to introduce your first speaker, Aaron.
Thank you, Kate, and welcome everyone. Thank you for joining us today to talk about tips for ethical billing and avoiding fee disputes with clients. I think that most of us joining the webinar today would agree that no one likes dealing with bills. We don't like sending them, and we certainly don't like getting them. I know I especially don't like that uneasy feeling of opening a bill from a vendor when I'm not really sure what the price tag will be. I don't like that initial feeling of uncertainty, and either do clients when they receive their legal bills. So before we dive into the discussion on ethical and unethical billing practices, I think it's important to remember that when a client hires a lawyer, they're usually doing so out of necessity. So whether they're being sued and they need a really good defense team, or whether they're beginning the process of a tough divorce, whatever the representation entails, a lot of clients are coming to you in a vulnerable state. So they're willing to spend their money to either get out of a bad situation or retain the best attorney they can afford. Some lawyers are only too happy to oblige, billing clients for every minute worked and then some in some cases. But is it ethical to charge a client more than $1,000 for an hour of legal advice? If you're on a 3-hour flight traveling for client A, but while in flight you're working on an oral argument for client B, can you charge 3 hours for travel to client A and also 3 hours of prep time to client B? Can 3 hours really add up to 6 hours of billing? These are some of the things that we will be discussing today. Eric and I have seen a lot of malpractice cases in the course of our profession in which lawyers found questionable ways to squeeze money out of their clients. Some are legal, but maybe in the ethical gray area, but they would most likely make a client's blood boil if they found out. And the economy is struggling right now, so we are seeing more clients slow paying their attorneys, needing payment plans, or not paying their legal bills at all. So learning some new skills around legal billing may help you face some of these challenges. Our focus today is going to be on some best practices for ethically billing and getting your bills paid without getting sued. We're going to provide you with some guidance on how to implement billing practices that can actually cultivate strong, positive attorney-client relationships. So with that, I will turn it over to Eric to talk about the ABA model rules on fees. Eric?
Thank you, Aaron. And I'm going to start off, as Aaron stated, discussing the ABA model rules, and in particular Rule 1.5 with respect to fees. Now, every state has similar, if not the same, rules as the ABA model rules. So whatever state you're in, look at the ABA model rules, but also look at your state-specific rules. So when we're talking about 1.5a, the rules talk about what is an unreasonable fee or an unreasonable expense, right? And the ABA rules list 8 separate categories that are factors to be considered when determining whether something is reasonable or not. Time and labor obviously is the main, or one of the main categories with respect to fee. And then that gets into whether it's a novel issue, a difficult issue, and the skill required to perform the legal services that are needed on that particular case or that particular issue that you're going to work on. So common sense, right, obviously dictates that there are different levels of skill that are needed for different areas. So example, antitrust cases, different than maybe an auto case or slip and fall. Medical malpractice, different than slip and fall or premises, right? If there's an international issue with respect to a federal court in other countries, that's all different, right? Criminal law, different than probate law. So you have to keep that in mind when you're coming up with what is a reasonable fee for your line of work. Number 2 is whether that acceptance of that employment will preclude you from having employment in other areas or other cases. Right? Not to be political here, but for example, people who are attorneys that are representing certain political figures right now that are going through legal issues, I assume those cases are very time-consuming, where it may be the only case that that particular lawyer or law firm works on right now. So that can be taken into account when determining what the fee should be. Where you are, obviously, big city versus smaller cities, New York City, San Francisco, Miami versus the middle of the country, that is also a factor. The time limits, right? Again, this kind of gets into a little bit of what the case is about, but is it a normal case where you have 2 years to litigate, take your depositions, and prepare for trial? Or is it a rush case where you're called on the last minute and it's around the clock and there's trial in 3 weeks, right? What is it? Is it due today or is it due, 3 or 4 weeks from now? The nature and the length of the profession, that obviously is important, and the reputation, the experience, the ability of the lawyer doing the work, right? A first-year lawyer can't be charged the same as the senior partner or someone with 10, 20, 30 years of experience, right? So all of those are important when you're talking about what a model rule and what the fee should be. So everyone always loves examples. I try to come up with examples of what is reasonable, not unreasonable. And it's not only the fee, but it's also the costs, right? So costs include things like miles reimbursements, right? Now, we're not traveling as much to depositions and hearings, if that's the line of work you're in, because a lot of things are done by Zoom, right? But if you're going to travel and it's 50 miles, you can only bill for 50 miles, right? It's common sense. You can't bill extra miles to make extra money off of whatever the IRS reimbursement rate is, right? Also important is if you're going to the courthouse or going to a meeting or going somewhere and traveling and working on 2 separate cases or have 2 hearings, you can only bill once. You can either split the time. So if it takes me an hour to get to the courthouse and I have 2 hearings, I can bill half an hour each, or I bill one client and the other client gets the benefit of having another client who's paying for it. So you can't bill 2 hours for an hour of your time, right? And that gets to double billing, whether you're flying or on a train or driving. All of that stuff is common sense. You can't double bill a client. So there's a couple cases I want to briefly talk about that I've read over the years in terms of what is reasonable or unreasonable. This was a bankruptcy case where the court determined that the attorney's fee, or the proposed fee of $2.6 million for 10 months worth of work, was unreasonable, because when the court did the math, that would equal 24 hours a day work for 300 straight days. Obviously, that is not reasonable or even possible to do. So the court reduced the fee on that and also reduced some overhead expenses like air conditioning on the weekend, right? So don't overbill. Don't take advantage of your client, right? And then I'm looking at the chat, and I'm not supposed to do this, but I just saw a question. How does the client know if you're double billing? Well, they don't, but you have an ethical duty and an ethical responsibility in your state's rules to not unethically treat your client inappropriately, which includes double billing your client for things that they shouldn't be billed for. So yeah, they may not know, but you know, and the ethical rules require you to not do that. Another case, this one is in Oklahoma. People always ask me for the site, so I'll cite it. 158 Federal Sup 2D 1278. This was an attorney who looked like he took on a case he shouldn't have taken on. When you have cases, you can't use a case to educate you and do research that is basic that lawyers should know that practice in the field. So in this case, the attorney was defending a Fourth Amendment case, an excess force case, and he billed his client more than 500 hours, all right? And a lot of it dealt with simple 11th Amendment issues and discussions with co-counsel, including 49 separate entries with discussions with co-counsel. And the court ruled that the inexperience of that lawyer caused the fee to be unreasonable. So you can't use your fee or your case to educate yourself on a certain line of work or know or use the case to learn things that you should know in your practice. Another example is a case where it's down in Louisiana, where the probate council accepted 5% of the estate to do the work. The estate was worth $1.14 million, and the court ruled that that percentage of the fee was unreasonable because no administration was required, no work was really done other than placing the heirs in possession of the estate. So I don't know how many hours was spent, but the court ruled it was not enough to justify 5%, which is around $57,000 for that simple work on that case. So it's a lot of it is common sense, right? Don't take advantage of your client. Don't bill them things that they shouldn't be billed for, depending on what line of work you work in. A lot of times if you do defense work, which is what I do, in the insurance world, you can't bill for administrative things. You can't bill for overhead. That's just part of the practice cost that you have for having a law firm. So, so in sum, right, only bill for your work. Only bill for the time that you actually do the work. Be careful with expenses. I've got a lot more examples, but time is limited to an hour on this presentation. And don't excessively and double bill, right? And it's sort of like what you tell your children, treat those the way you want to be treated, right? Bill those clients the way you want to be billed, right? And I think that is important. And think of that when you look at the model rules. And it's all important when we speak to model ruling. So let's jump ahead to 1.5b, which is retainer agreements. And I actually just had an issue with this with a client that came up recently. Now, retainer agreements do not have to be in writing, but they should be in writing, right? The model rule says that it's preferable to be in writing. And I think it should be very preferable to be in writing, right? Because you want to set forth in your retainer agreements what your scope is in the case, what your role is in the case, and we're going to get to this later as well, and what your job duties are, as well as what your fees are and what you get reimbursed for, right? Because clients need to know that they're getting charged for things like copies, subpoena fees, flights, other attorneys, including paralegals. Sometimes they don't know that if the client is not sophisticated in the world, in the legal world. FedEx, miles, all of that needs to be set out, and the best way is to do it is in a retainer agreement. You should update your retainer agreements, right? Don't use the retainer agreements from 1970 or older because times have changed, right? There's a lot of things that are different now, obviously, than it was back if you're using an old cut and paste retainer agreement. Even if your retainer agreement now is up to date, every case and every client is different, right? If you take the time, 15 minutes, before you finalize your retainer agreement, it can prevent issues and problems down the road with that client, right? Because you want to lay out, again, what your scope of your representation is in that case, right? Because it protects you, but it protects the client, and it eliminates confusion between you and the client of what your job and your role was, right? So, for example, if you're practice in the field of immigration and you're hired to fill out an application and represent the client at a hearing before the immigration court, right? But you don't do the appellate work. Make sure you put that in the retainer agreement in some way, so that if you have to do appellate work or if the client has to seek appellate review, it's got to go to another lawyer, right? Because I think the best practice, again, is to include as much detail as practical in your retainer agreements, not only for billing and cost, but also what your scope is, right? Make sure it has areas about your right to withdraw, the client's right to terminate. Can you withdraw for non-payment of fees? Yes. Make sure that is in there. So the client is fully aware of what the requirements are. Moving on to 1.5C, these contingent fee agreements, they shall be in writing, right? So they must be in writing, and they must be signed by the client, and it must state the method by which the fee is to be determined, right? Most of these are plain of attorney fees. There can be some in real estate and other lines of work depending on the sale price and closing price. But when we think of contingent fee agreements, we think of plaintiff lawyer agreements, right? And every state has, I believe, I know Florida does, has the requirement of what the percentage is depending upon what the eventual outcome is. Make sure all of that is in the contingent fee agreement, as well as similar to retainer agreements, the expenses, the deduction from recovery, when it is when it is taken from the award or the judgment, right? Is it taken before you take your fee? Is it taken after? I know most people do it beforehand, right? All of that should be in there, and at the end, of course, you should have a closing statement. 1.5D, this limits how you can enter into an agreement. There should not be contingent fee agreements with respect to domestic relation matters or criminal cases, right? You don't get paid X plus a percentage if you represent one spouse and you get custody of the kids and you get the house, right? For criminal cases, you don't charge X if you plea, Y if you get acquitted, and then Z if you're guilty. It's not allowed under the model rules. And just be aware of that if you practice in that. With respect to a fee between lawyers, that's a referral fee. E, that's pretty self-explanatory, right? It's all got to be in writing. No side deals, no handshake deals, things like that. So there's a bunch of cases that are examples, right? And some of them, I think are important because I think when you're talking about referral fees, right, they have to be in writing, and the client has to know about it, and the client has to sign off, right? Because there's plenty of cases where attorney A refers to attorney B, client obviously knows about it, but doesn't sign off on it. And then if there's an oral promise of the attorney to pay the referral fee, that's not enforceable if the client doesn't sign off on it. And there's a couple cases. One of them is, I don't have the site, but I know it's in Texas. So just be aware if you're referring cases that it's in writing, it is signed off by the client, and it's proper, and they all also have the fee division. So with that, I am going to pass it over to Erin to talk about intake procedures.
Great. Thanks, Eric. And I think your examples of how Rule 1.5 really applies to realistic billing practices were just spot on. So, shifting gears a little bit, let's look at intake procedures and more specifically how they can help avoid billing issues down the road. I think all too often attorneys want to practice law and not deal with the business piece of running a law firm. But your client intake process is often your client's first experience working with you and your staff. For your new clients, the intake process can either validate or invalidate their decision to work with you. So don't miss a great opportunity to improve your law firm's performance by doing a bit of work on the intake process. It could yield some long-lasting benefits. So ask yourself, when a client comes into the office, what are your typical intake procedures of the firm, and are they working? Taking time at the front end to do certain key things during new client screening and intake can give you more certainty that you will be working for reliable clients and getting paid. So what are some of those key things? You want to have a standard potential client intake form with a template of questions that elicits the information that you need for client screening. I'm a big fan of using forms as a starting point for things like client intake, engagement, and disengagement letters, as well as fee agreements. One size may not always fit all, but forms are a great place to start to be sure that key things are not forgotten. Forms are also a great starting point for the client interview. The Florida Bar Association has a pretty good initial client consultation interview form, and it's on their website, which you can see on the slide here. It can be a great launching pad for the development or the refinement of your own. So I'm going to walk through just some of the things that it contains. It has this great lead-in paragraph about the purpose of the initial consultation. It says, the purpose of the initial consultation is for the attorney to advise you, the prospective client, what, if anything, may be done for you, and to assess what the minimum fee therefore will be. The purpose is not to render a definitive legal opinion, as it may be impossible to fully assess a matter within the time frame allotted for a consultation or with the information or documents that you may be able to provide at the initial consultation. It also advises one of three outcomes is possible following your consultation. 1, you and the attorney mutually agree to the terms of the representation. 2, the attorney declines representation. Or 3, you decide not to use the services of the attorney. These upfront expectations clearly set the expectations out of the gate. I also really like the section that says, knowing there are no guarantees, what can you accept? I think questions like this really get the potential client thinking about how they see the matter moving forward. Another great question on the form asks, if the matter involves payment of money you feel you are owed, how long can you wait before not getting paid? Days, weeks, months, years? This is a good one. If they write down, I need it tomorrow because I'm flat broke, you should start seeing some red flags. Do they have money to pay their legal bills? Another great question is about prior representation on the matter. Don't you want to know if they were fired as a client by another attorney? I actually handled a case where I could not understand why this firm took on a client. By the time the firm that I was defending was hired, the client had already been represented by 3 other law firms and had sued 2 of them. Not surprisingly, she decided she was not happy with my lawyer's services either, and then ended up filing a malpractice suit against the firm and refused to pay any of the legal bills, which at that point had added up to a significant amount. Do you think the firm should have taken on this client? Should they have been surprised when she did not pay any of her bills and then turned around and sued them? Probably not. So keep in mind, it's a huge red flag when a client is changing lawyers in the middle of a case. It's even a bigger red flag when they're suing their former lawyers for legal malpractice. They're either trying to avoid paying their legal bills or they may be difficult to satisfy. But either way, you may not want them as a client. So use this intake form to gather information to properly screen a potential client. Again, the Florida Bar Association form is really good. It asks great questions, and I think it really does get the prospective client thinking about their expectations as well. Now, once you've reviewed the form, there should be that face-to-face interview. And during the interview, you should learn more about your client's issues. Some you might be competent to handle, and others you may not. Remember, doctors send patients to other experts when something's outside their scope, and so should lawyers. This is also when you have to be honest with yourself about your current caseload. Do you have the time and resources to properly handle this matter? Make sure you know the rules of professional responsibility within your jurisdiction and the obligations that you have to your clients. Be mindful of your duties to the client, diligence being one of them, as well as the client's rights, such as the right to be promptly informed of all developments, and make sure that you can adhere to them. If you're a small firm and you anticipate being inundated with documents, depositions, motions, should you take this case? You could miss deadlines or not have time to communicate with the client, and this could result in the client refusing to pay their bill. They're angry, they're feeling neglected. You also want to use your instincts when accepting a client. Take adequate time during the initial interview to develop a feeling as to whether the client's going to be a problem. Do they have unrealistic expectations? Are they truthful? Are they cooperative? Does the potential client seem extremely disorganized or all over the place? This can not only be extremely frustrating while representing them, but it's a pretty good sign that they're not going to pay their bill because it's either misplaced or accidentally thrown out, or maybe they're so frazzled they've completely forgotten about it altogether. Another type of client that can be a potential problem when it comes to paying bills are those who nitpick or are really difficult to satisfy. If the potential client seems particularly nitpicky about things, well, there may very well be a good chance that they're not going to be pleased when the representation comes to its conclusion, and they may use this as the reason for not paying their bill. You should try and make an assessment up front as to whether a client can afford your services. There's several approaches to determining if a client can afford fees, giving the client a reasonable estimate of fees and expenses, and then judging the potential client's reaction can help avoid problems. If your first reaction to discovering a billing problem with a client is, I knew this client was going to be trouble, or I knew I shouldn't have taken this case, you probably need to do a better job screening potential clients. So in summary, some red flags that a client could burn you on billing would be changing lawyers in the middle of a case, trashing the lawyer they just left, reluctance to answer basic questions, providing inconsistent or even incomplete information, and then wanting to use the legal system as a weapon of revenge or retribution. So be smart. Don't ignore the red flags or even that gut telling you not to take a client. Remember, you have the choice not to take a case. If you're looking for more information or some more tips on client screening, we do have an article called Spring Cleaning, and it's all about client screening and some, again, additional tips on that. So that's on the Attorney Protective website if you're interested in learning more about client screening. But moving on to intake procedures. So after the initial interview and the checklist, you decide to represent the client, right? So once you've decided you can and will accept them as a client, you're going to need to translate your agreement into an engagement letter and a fee agreement. So obviously the scope of an engagement letter is much broader than just fees, but today I'm just going to focus and address the fee aspect. You've already discussed the fees during the client intake process, so it should be pretty easy to reduce the understanding to writing. The agreement should be straightforward and understandable. If there was not a clear understanding about the fees and expenses up to that point, it should be clear now. Keep in mind, many disputes between lawyers and their clients are about money. So the engagement letter should set the attorney's fees, the associated costs, and how and when the client will pay. Because if there is a dispute down the road, the agreement can assist in fee retention. A written contract forces both parties to be very clear about what they expect of each other. The engagement letter also assists in managing risk arising from a legal malpractice or a disciplinary liability. So what should be in this engagement letter to ensure you don't run into billing issues in the future? You should make sure that you specify the name of the client. The engagement letter should include the fee arrangement and expectations for payment. How much will it cost to achieve the intended result? If it's a contingency, clarify what costs the client will be expected to pay. If it's hourly, prepare the initial budget. Keep in mind that generalizations can get you in trouble. You also want to set forth detailed scope of professional services to be provided, as well as the services the firm's not providing. I've handled many legal malpractice claims, and a lot were filed simply to reduce legal fees. But when the bill is so general, it makes it more difficult to defend. I saw things like 50 hours spent on case X, Y, and Z at $400 an hour. You owe $20,000. Please pay immediately. The client deserves to know what you spent your time working on, and this is why itemized accounting is a good idea. Where exactly did those 50 hours go? If you claim that you wrote a letter to opposing counsel for 4 hours and the letter turned out to be 2 paragraphs long, your client has the right to seriously question your time management. So itemized accounting, it helps keep you honest too. The engagement letter should also include important dates and potential benchmarks, and also outline the responsibilities of the attorney and the client. This one's really important when it comes to avoiding potential billing issues. So you want to explain the process as far as what's expected of your client as far as document production, depositions, interrogatories, the difference between settlement versus trial, or experts and other expenses. How long will it take to resolution? Remember, if you're upfront with the client about what is expected of them, what's expected of you, and then you have it in writing, if there is a fee dispute later, you have this agreement to hang your hat on. If the scope of the representation is questioned after the fact, you'll be in a much better position to substantiate your version through the engagement letter. And this same principle applies to non-engagement and disengagement letters. So you'll see on the next slide, when talking about engagement letters, I thought it was also important to quickly address non-engagement and disengagement letters too, because I get asked a lot about whether a firm should incorporate disengagement letters into their practice. Of course, I do recommend that lawyers incorporate closing or disengagement letters into their practice to help clearly communicate that the representation is concluded. Disengagement letters, they provide powerful evidence of the date the attorney-client relationship terminated. Essentially, a closing letter, it transforms current clients into former clients for purposes of avoiding conflicts with other prospective clients. The absence of a disengagement letter, it's contributed to the filing of legal malpractice claims by persons to whom the lawyer believed they no longer owed a duty. A common legal malpractice scenario is that without a disengagement letter, a client later alleges that the attorney failed to follow up on a case before the expiration of the statute of limitation. So a disengagement letter, it avoids credibility issues with the former clients, especially in situations where the attorney has represented the client in multiple matters. Without a definite termination date, the statute of limitations for a malpractice claim can effectively cease to begin running. So disengagement letters can provide attorneys with a level of comfort that the client understands that representation has ended and that the attorney is no longer responsible to safeguard their interest. The disengagement letter can be short and to the point, but it should make clear that the representation's ended, and it should include the date of the termination. Firms can also use the closing letter to remind the client of the firm's document retention or destruction policy, and also use it as an opportunity to reinforce the quality of your work and encourage the client to look to you and your firm for any future legal needs. Again, there's some great forms for all of these letters available online that you can use as a template and then tailor to your own firm's needs. I listed one here on this slide too from the California Bar Association. It's another great place to find fee agreement forms if you are looking to update yours. And we also have some on our website as well at attorneyprotective.com. So on the next slide, I also just have a sample non-engagement letter here. And again, as a risk manager, I just get asked this question a lot. So I wanted to just provide a template for anybody that is looking to incorporate these into their practice. So moving on, intake procedures. On clearing away the smoke and mirrors, I want you to stand in your client's shoes for a minute. As a consumer, we expect a level of certainty when it comes to services or products that we purchase. So whether it's a monthly credit card statement, a plumbing bill, or whatever other invoice I receive, I want an itemized list so I can go through each item and confirm that they are legitimate charges. So think about it. Does your client really understand how expense items are generated? For example, if you're handling a case in another county, there may be additional expenses associated with that. And Eric talked about that earlier. Does your client understand that? So you want to provide itemized bills, which again we touched upon a little bit earlier, but also make sure that you review them for errors. All associate bills should be reviewed by a partner before a client's billed. You want to look for errors such as double billing, charges on a wrong file, and also if the amount of time spent on a particular task is reasonable. It would also be a good idea to compare the bill to the fee agreement that you and the client agreed upon at the beginning of the representation. And then be sure that you're not charging or overcharging your client for any items that were not listed in the fee agreement. You also want to avoid vague billing descriptions. Complete, detailed, and accurate task descriptions are the easiest way to prevent a client from flagging your bill. Every task description should identify the activity with sufficient detail to assess its necessity and its relevance to the project. So along with a detailed description of the task, each time entry should include the date the task was performed, the timekeeper who performed it, and the time spent performing the task, and then the total fee. Your client may question why you billed 45 hours in reviewing and revising a brief. Well, perhaps the brief was really long and it involved multiple complex issues and extensive research. Whatever the reason, vague terms like review and revision, they do little to inform the client why the review merited a week's worth of time. Simply giving clients hourly rates, it doesn't really give them the full impact of the cost of services in more complicated matters. Estimating the full cost of representation, it helps them understand how expensive the matter might be. So you want to make it clear that you must get paid regardless of the outcome and that there are downside risks to litigation. clients who are fully informed about costs and risks are less likely to complain about fees. Eric touched upon this already, but all fee arrangements should be in writing. Combining fee agreements with engagement letters specifying work to be done is a very efficient way to assure that communication about fees are in writing. Keep in mind that a well-informed client is likely to pay their bills, so you want to routinely connect with your client. Bill at regular intervals, you want to return calls promptly, or even I see a lot of attorneys provide office hours, so that's times when you can make yourself available for client calls. And then keep the client informed of changes in evaluation and make sure you're putting that in writing. You should update your client when there is a change in the evaluation or budget, and you should try to do it as soon as possible and explain why. Did the evaluation change due to an expert report? Or did your client or the opposing party perform better or worse at a deposition? Things like that. Because communication with the client, it's not something that lawyers should just consider at the beginning of the representation, but really throughout the life of the case. As the case progresses, provide clients with documents which have an effect on their prospects for success or failure in the litigation, and then discuss any developments which either increase costs or decrease the likelihood of success shortly after they occur. Provide the client with new estimates of costs in writing as the case continues. You just really essentially want to take any guessing on the client's part out of the billing equation. Requiring a retainer and requiring that the client replenish it on a regular basis provides a way to weed out those clients who are less likely to pay when the bill comes due. As the case progresses, talk to the client as soon as the bill goes unpaid or the retainer is not replenished as agreed. Certainly, there's going to be situations where a lawyer may consider floating a client for a short period, but it's common for clients to fall behind and then never catch up. And it's best to withdraw before the bill grows even larger. But withdrawal becomes a lot more difficult as litigation or transaction approaches its conclusion. So on the next slide, I'm just going to quickly talk about withdrawal for non-payment because this is another question I get asked a lot about. Can a lawyer withdraw from representation or representing a client for failure to pay their legal bills? So the general rule is that a lawyer may withdraw from representation when a client refuses to pay the attorney for services in violation of the fee agreement, or if the representation causes a lawyer financial hardship. And this general rule holds so long as the withdrawal is not materially adverse to the client's interest. Despite best efforts, some clients still may not pay their legal bill. Some precautions to help mitigate the risk of non-payment include using adequate retainers and flat fees since you take the money up front. The fee agreement should set clear expectations for payment and the consequences for the client's late payment or failure to pay. Will work stop until the account is current? Will the client be charged interest? State in your retainer agreement that non-payment is grounds for withdrawal. Utilizing these types of provisions in the fee agreement, it can help avoid situations in which you're contemplating withdrawal for non-payment of fees. So best practice tips regarding withdrawal for failure to pay legal bills. The first step to avoid being in a position in which you need to withdraw due to non-payment of fees is to determine upfront whether a client can pay their bills. And this is why thorough client screening is so important. Keep in mind that non-payment is not a defense to non-performance in a legal malpractice action. So a lawyer seeking withdrawal for non-payment should take reasonable steps to provide sufficient notice to the client so that substitute counsel can address pending motions or prepare for trial. Finally, be sure to avoid disclosure of any confidential client information. Okay, so next we're going to move on to 7 billing tips. The number one tip, I would say, is happy clients don't sue, and they generally don't complain about a bill. Believe it or not, there are plenty of clients out there who are thrilled with their lawyers despite them not having gotten the best possible outcome for their case. So you might ask, how is this possible? It all comes down to a positive client journey. Once you start adopting the mentality that each stage of the client journey, it's an opportunity to delight, then you start transforming the way you run your practice. Now, keep in mind, if you fail to return repeated phone calls or emails, you may not get paid, but you also may be violating your ethical responsibility of communication. So if you're busy working on another case because of an impending trial or you're tending to a sick relative, let the client know this. Most clients will understand and will appreciate the honesty, But again, I think it's really important to set expectations so the client isn't feeling neglected or forgotten. Developing a strong client relationship can help pay off in the long run, and this really means that you have to listen as much as you talk. So doing simple things like asking open-ended questions as far as, this is typically how often I will report. Does that work for you? Or what form of communication and reporting would you like? It helps the client feel like they have some control and are part of the process. And even more importantly, if you understand the goals and expectations in the matter, then you can try to accomplish them. And the intake form that we discussed earlier can certainly help with this, but also keep in mind that it's better to ask these questions up front to ensure that you're meeting expectations. Ask their opinion about how they think their case or matter should go. Even if you think they have no expertise to offer, that doesn't mean that they don't have opinions. And if they do, you need to hear them. So sticker shock. If there is going to be a big bill or other negative news, don't let the client hear it from the mail carrier first. Communication is really important in invoicing success. We're going to talk a little bit more about communication later in the presentation, but when it comes to managing the client relationship, if you've noticed that your invoice in a billing period is going to be way off course from your client's expectations, don't ambush them with a terrifying invoice. Pick up the phone, give them a call, let your point of contact know exactly what's going on. Deliver the bad news concisely, clarify the who, what, when, why, and how, and then add that explanation to the invoice so they don't have to try to remember that you called them on the phone. Let your point of contact and the billing department know what's coming ahead of time. Also, make the bill easy for them to pay. So possibly offer online payment solutions. Online payments offer the client more options to pay, making it more convenient for them to pay you. There was actually a recent study that showed that law firms are getting paid almost 40% faster by using online payment solutions. Fostering happy clients often leads to repeat business and positive reviews for your services. Your bottom line can only stand to benefit from making your bill easier to pay. So that's something else to think about. Also, it never hurts to include a personal touch like a handwritten note or client newsletter with a bill. Mail your clients birthday greetings or holiday cards. I actually once read that the effect a personal gesture has is usually proportionate to the effort it takes to make it. And I think about this all the time because I really do think it's so true. It takes time to write a personal message, but the gesture is usually remembered and really appreciated. I think especially today when less and less firms are doing it, it's actually a really good way to stand out and be remembered. Another point is bill immediately when you achieve a major milestone. Tie items billed to clients' hoped for results. Billing immediately when you've just achieved a major milestone in a case, it makes perfect sense. You've probably heard the phrase, striking while the iron is hot. Well, usually achieving a major milestone is expensive. So celebrate the success with the client, send them the bill, and do this before the euphoria is over. I would also include the client's recent or previous payment on the invoice. This is a form of positive reinforcement. So just another suggestion. And then keep in mind that it's inevitable that there will be inefficiencies on a bill from time to time, so disclose inefficiencies and write them off a bill. When retailers write something off, I always kind of feel like I won something, so that's just something else to keep in mind. And then make sure you tie billed time to clients' hoped for results. This sends a huge positive message that you listened to what they wanted and you did what they asked. Okay, so finally, having the tough conversation. Why aren't you paying the bill? Most risk management experts will tell you that it's a bad idea to work for a client for months without getting paid. I think common sense tells all of us this too, but more and more lawyers are doing this today, often driven by an optimistic or even possibly an unrealistic belief that clients will eventually pay them, or it could be driven by the fear of having no client in the wings to replace that business. So what do you do when a client's not paying their bill? Well, don't just keep sending letters. Call them. The lawyer is often the best person to call, not just a billing clerk or a bookkeeper. So think about getting the attorneys involved when a client stops paying their bill. In both large and small firms alike, this task usually falls on the shoulders of paralegals or secretaries or clerks who are instructed to make collection calls when they can sneak them in around their other work. As their lawyer, you or the lawyer involved, they already have a relationship with the client and hopefully talk to them on a regular basis. So if you're getting pushback from lawyers in your firm about helping out with receivables, maybe explain how better collections means higher profit margins and more money without having to work additional hours or raise rates. Usually if a client is not paying you, there's generally 3 reasons why. 1, they have no intention of paying you, and therefore they're going to use all means they can think of to avoid paying you. 2, the cost of the representation was more than originally anticipated, and they're having a difficult time making a full payment. This is actually the best case scenario. They may be embarrassed, so they're avoiding you. But if this is the case, then reach out to them and try to put together a reasonable payment schedule. The 3rd reason may be they're mad. They're either unhappy with the progress of the case, they're dissatisfied with your work or your billing practices, or they're angry about the lack of communication, and this is the one we see the most. And not paying you is one way they can send you that message. Taking a step back, many clients are nervous about working with attorneys. Legal bills can exceed most other expenses. I mean, they can even exceed a car. Also, clients may be confused about whether certain things are itemized or concerned about inflated billable hours, which is reasonable when you come across the headlines like some of the cases that Eric just talked about. So a lot of clients have a fear that they're going to be cheated somehow. And once they flag a bill, the first time they do it and they see something wrong, they're probably going to go through each one with a fine-tooth comb after that. And I think as consumers, we can all relate to that. So keep in mind, your invoice has a tremendous amount of power. In the right hands, it's a tool that you can use to boost realization rates and confirm or deny the image of your firm. It's a helpful way to encourage loyalty and support, or it could be a surefire way to turn clients off. So with that, Eric, I'm going to turn it back over to you unless there's anything else you would like to add regarding billing tips to talk about avoiding fee disputes.
Sure. Thank you, Erin. And yes, I just want to kind of add and supplement a little bit of what Erin said regarding 7 billing tips. And I think what she said about picking up the phone is sort of a lost art in today's world. I think everyone likes to send emails or chats, but if you pick up the phone, right, a lot of times when there's issues with bills, clients either miss it in their emails, as we all receive hundreds of emails a day, right? So pick up the phone. I think Erin said pick up the phone when there's good news, right? Pick up the phone to update a client. Pick up the phone if there's a bad ruling or a bad deposition or bad news on a case. Clients want to know and they want to get kept up to date. I have never in my practice in 20 years ever had a client say, stop updating me about a case, right? So I think as you're billing them, and if they know what's going on in the case, then when they receive the bill, they're going to say, well, my lawyer is doing a lot of work on this case, and he is keeping me up to date because he's calling me. Another thing that Erin talked about was the summary judgment hearing or a big motion or a big brief, that's 45 hours. Break it down, right? Break it down, what sections you're working on, what part of the brief or the motion you're working on, and obviously send it to your client so they can see how great you are and how much time and effort you put into the motion. One more little tip I think on billing that I think clients appreciate, just like when Erin goes to the store and something gets written off or there's a discount by the teller or something when we're buying or shopping, right? Clients want to get stuff for free, right? So even if it's a telephone call that lasts 5 minutes with the client, right? I'll put it on the billing, 0.1 telephone call with client about whatever, and then I'll no charge it, right? 1, it looks good, clients are happy. 2, they feel like they're getting something for free. And 3, you don't ever want to, I think, bill your client so much that they don't want to talk to you, right? Because you want to get information, you want to be able to know things that your client needs to tell you, and if they always want to cut the conversation short because they're afraid you're going to charge them for every minute on the phone, they may not talk to you. So those are just a couple of my add-on billing tips. But let's go to the next slide, which is avoiding fee disputes. And just so everyone probably knows or thinks about, if you sue a former client, more likely than not, it's going to result in a counterclaim for malpractice. That's more than half the cases that I end up getting in the malpractice world are counterclaims after the lawyer sues for money. It's just the way it is, right? So the full cost of suing your client has to be considered before you go that route, right? It's not only a counterclaim, right, because that's always a possibility. It's also the other attorney getting discovery, getting your files, taking your deposition, getting all of your billing records, getting all, depending on the case, your internal records and software management. It's also about having a lawsuit where you're being sued in the public domain, right? Where anyone who's thinking about hiring you is just going to go onto the clerk's website and see your name and read the allegations, whether they're true, hopefully not, or not true, right? So you want to avoid that. You want to avoid any negative press, and you want to avoid having a lost client. So suing for fees has to be, I don't want to say the last resort, but you definitely have to make a pros and cons of doing it, because more likely than not, it results in a lawsuit, and Erin and her team, that's how they get a lot of claims for their insureds, right? So that is one issue. Now, managing receivables, and Erin touched on this a little bit, right? You don't want to let it get out of hand, right? 1 month, 2 months. I think there's research that once something gets 90 days or 120 days past due, it is really hard, really hard to get payment from that client or that vendor or whatever industry. But especially for us lawyers, it's hard to get it once they're 120 days back. So don't ignore it. Don't put your head in the sand. Pick up the phone. Like I said, a lot of times if you call a client and you start off with a joke or something, hey, I'm sorry I have to call you about this. I need to follow up on a fee. The excuse more likely than not is I didn't see it, or I'll follow up on it, or it's lost in my email, right? So every business has a right to get paid, right? Don't be afraid to ask and talk to your client, because again, most of them are busy. They forget. There's internal issues. They send it on to accounting. Who knows? We could think of 10 different reasons, right? But be proactive in order to manage your account receivable. If you need to put them on a payment plan, you can talk about a payment plan. Erin talked about early payment discounts. A lot of firms do that. You pay within 30 days, you get 2% off, things like that. All of that works. All of that is kind of a new developing market in the payment world. So the next slide, avoiding fee disputes, right? Pay attention to the warning signs, right? What are some of the warning signs? Obviously, them not paying your bill, right? But what other warning signs? Not returning your phone calls, ignoring your emails, not cooperating with a case, questioning you on why are you doing this on a case? Like, why are you taking Mr. X's deposition? Is that really necessary? How much is that going to cost? Just being rude to you. Those are some of the warning signs in terms of what might be coming down the road, right? If they're only concerned about the costs and not what the goal of the representation is, whether it's litigation or otherwise, that's a warning sign. Obviously, there's other warning signs like, bounce checks, multiple extensions, right? I think it's important, that you listen to your gut, right? Follow your instincts. See the warning signs. Heed them, right? Because if it snowballs out of control, then you're eventually going to, like we discussed earlier, terminate your relationship because of non-payment of fees. And then the chances of getting the money are even less than if you work with the client. So knowing and paying attention to the warning signs is very important. So with that, I'm going to pass it back to Erin to talk about client communication, unless she has something to add about avoiding fee disputes.
No, I think you covered avoiding fee disputes really well. So I know we've already talked a lot about the importance of good client communication in avoiding fee disputes. And as I stated in the beginning of the webinar, really a good offense is your best defense. So set the fees and the billing structure straight at your client intake interview, and then confirm it in the engagement letter. And if you were honest about how much the fee could be, there is less potential for the client to feel surprised or betrayed by that issue later. And if you were honest about the fact that unanticipated events can change the fee later, when it happens, they are less likely to feel like you pulled a bait and switch on them. So some good reminders are keep clients posted on the progress of the case and how that relates to their money that you are spending. Let the client speak. If the client feels like they're being heard and they feel like they're part of the decision-making process, they're less likely to be critical when things do not turn out as expected. Realistically, we can't hide behind the excuse that we can't anticipate the fee. Clients want to feel confident and have a sense of certainty with their lawyers, and they want this certainty for their budgets too. No one likes unanticipated fees. It doesn't sit well with any client. And clients want value, or clients really value reliability. So keep that in mind. I think reliability is a really important piece. Did you do what you said, and did you get it done within the budget and the timetable you said? Again, as consumers, I think we all understand how important this is and how much reliability is valued. Remember, when you want them to come back for any future representation needs, you want them to think of you in high regard. So getting it right on big things like billing practices means you can ensure that future business. So certain good experiences, as consumers, we can relate to this, they keep you coming back to certain stores or certain vendors, while negative experiences may have turned you completely off from that store or that vendor for good. And then worse, they could even badmouth you to other potential customers. And this works the same for your legal reputation. So just to end this, I would say before you engage a collection agency, I would recommend that after reaching out to the client to ensure that the client does not have a reasonable basis for non-payment, send a final demand letter. And this letter should outline your rights as a creditor, their rights as a debtor, the specific time they have to make the payment, and the actions you will take if they do not remit payment, such as turning their account over to a debt collection agency. However, keep in mind, the client could respond with a malpractice claim, like Eric said, even if it's a mere defense mechanism to avoid paying the legal bill. So if the dollar amount owed to you is relatively small, it may not be worth your time to pursue. Calculating how much debt to walk away from will involve the specifics of your situation. So what you'll see on the next slide is that I added a sample collection letter here. So if you find yourself in a position where you need it, this is just another template that you can use. But hopefully with all the tips that you learned today from Eric and I, you will not need this, but you can keep it in your back pocket just in case. So I would say, just in summary, your billing practices, they actually have tremendous amounts of power as far as if you have the right procedures in place, it can help instill trust and loyalty with your clients. If your firm is walking that ethical line when it comes to their billing practices, it has the power to tarnish the reputation and the image of your firm. So hopefully you will take some of these best practices away with you today and feel more confident in how to screen for your potential clients to protect yourself from getting burned by any billing. So with that, I'm going to hand it back over to Kate to open up our Q&A. Kate?
Great. Thanks, Erin. We've got some questions coming in already. First, is preparing hourly billing statements billable time?
Sure. So this is, can you bill for billing, essentially? Many courts have invalidated methods of attorney billing, especially in recent years. Some examples of billing practices often found to be improper include time spent on billing and collections. So I think even more importantly, think of the optics of this. If I get a bill for detailed billing or for billing statements, I'm going to be mad if I'm the client, right? And I'm definitely going to be flagging your bill in the future. So I think even more importantly is the optics that are involved in billing for billing. And Eric, what would you say? Would you agree with that?
Yeah, I would agree, and I think it's more of the optics of it. I think no one wants to get a bill for an hour to prepare a bill to then be paid by someone, right? Think in your own world, right? If whoever you hire spends a half an hour preparing a bill to then charge you, it just doesn't seem right. I think I don't think it's allowed by the courts as well as I think the optics of it just does not look good, and like you said, probably flags your bills moving forward.
Here's another good question. Is there a duty to find a new attorney for a non-paying client?
I'm sure I can take this to start with,
Sure.
Aaron, if you want. And I think the answer is no. I don't think there is a legal duty if you're withdrawing or terminating representation to find a new lawyer for that client. But I also think that if you are attempting to help a client find a new attorney, that could be considered ongoing representation until a new attorney is found, and you don't want to still represent the client or be perceived to represent your client or that client when you really aren't. So I think there's no duty, and I think the best practice is to however it ends, to end it and then set forth whatever you need to set forth in letters, and I think Aaron probably talked about them, or they're on the website about what needs to be put in the letter when you disengage, and then disengage, and the client can find their own lawyer.
Yeah, I think that's a great answer, Eric. And I would just add, if you're referring a non-paying client to someone that you consider an acquaintance or even a friend, they're probably not going to be too happy with you. just another realistic thing to keep in mind.
Good point. Thanks, Aaron. What are your thoughts about flat fees?
Well, I'll try to keep it PC here, but personally, I'm not a fan of them, not for any particular reason. Then I think it's an opportunity or a door where you, the lawyer, can potentially be criticized by your client for not doing something on a case because of the fee issue, right? So let's say you get paid X per case, if you're in litigation. Well, sometimes on cases where you're getting paid a flat fee, there's additional work that needs to be done, but the lawyer subconsciously may not want to do it because they realize, well, I already got paid, and if I keep doing all of these depositions, it's going to end up not being worth what my normal hourly rate is. So if you don't take a deposition for whatever reason, even if there's a good strategy for it, for not taking it, if things go wrong, the client could maybe use that against you moving forward because you're not defending the case like maybe you would if it was hourly rate.
Yeah, Eric, I absolutely agree with you. This is more of a trend right now, I would say. So I think it sounds like it's something a lot of clients want, and it sounds like it could be a good idea. But to Eric's point, you really have to be careful because a lot of times you end up doing a lot more work than you're getting paid for. So I agree with you, Eric.
Mm-hmm.
Here's a question about fee increases. Do you need to advise clients of changes in billing rates, for example, annually, or is it enough to put in the engagement letter that fees increase annually?
We talked so much about client communication, so here I would say absolutely have it in the engagement letter, but also discuss this with the client. You can't over-communicate, and I think Eric said no client's ever been upset with over-communication from their attorney. So I would absolutely advise the client as well as putting it in the engagement letter.
Correct, and I would, call them and then also follow it up. If it's not in the engagement letter, the rate, definitely an email or some type of document where the client agrees, even if it means them signing a supplemental engagement letter or something along those lines, just so the fee is documented somewhere in case there's an issue down the road.
Great, thanks, Eric.
Mm-hmm.
Can a lawyer charge the client their hourly rate for time spent defending a lawsuit filed by the client for malpractice or reasonableness of fees?
I'll jump in here first. So one, if you're sued for malpractice, your malpractice carrier is actually going to be handling your defense, not you. So hopefully you have legal malpractice insurance. If you don't, jump on our website, but they're actually going to be the ones defending you and your case. So you shouldn't have to worry about an hourly rate for that, because if you have malpractice insurance, your carrier and the defense counsel that they hire on your behalf, who are experts in legal malpractice like Eric is, they would be the ones actually handling your defense, not you.
Yeah, and I would just add, if for some reason you don't have malpractice coverage, not only should you get it, but also if, let's say, you're representing yourself, at least in Florida, in a malpractice claim, unless there's a proposal for settlement or some other nuanced issue in a case, you don't have a right to charge someone else for you defending the allegation claims. So I think the simple answer that we both agree on is no.
On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. I would also like to thank our speakers, Eric and Aaron. Thanks so much. Have a great day.